Welcome. This is the module on the characteristics of a trust. This is needed for any financial planner who is going to be working with clients, be it as a trustee, be it as a financial advisor for a trust, or giving advice for your client in the areas of trust. And we expect you to have a little bit of background before you get into this, but this goes into more detail. We have several objectives in this module. First, we're going to describe the major characteristics of a trust document. We're going to cover the role of the trustees. We're going to cover the issues associated with powers of appointment. And it's going to explain the causes that granted trust create and the ramifications. And we're going to explain the sources of authority for the trustee. Income beneficiaries. There's two basic types. We can have a mandatory payout, which all funds must be paid out annually to the beneficiaries, and that is very objective in nature. And if you don't want to do it manually, you can do it like every 5 years, but it's a scheduled event. Discretionary is when the trustee picks what he wants to pay and when he wants to pay it. It's also referred to as a sprinkling or a spraying trust. And they need not pay out all the income that comes in. They can retain some within the trust. When would you use these? Well, mandatory is if you want a series of payments for your beneficiaries. And again, they could be yearly, monthly, every 5 years when they turn 35. Discretionary is where you want to give to the people who need it. You might have 2 or 3 relatives who are going to be the beneficiaries of the trust. And quite candidly, you never know what's going to happen in the future, so this gives a lot of discretion on the part of the trustee. You should always be sure that the trust is specific as to what the trustee can do. In other words, can they do it just because they like the situation? Should it be based on economic conditions? Should it be based on request of the beneficiaries? Whatever that criteria is, the trustee should be advised and included in the trust so that the trust does not get in trouble for doing what he or she thinks is the right thing. Wording to use with discretionary trust. Well, we have the subjective standards. And again, such amounts at such times, or not to pay or not to pay, that is the issue. We can exclude 1 or 2 persons if there's more than one in a class. For example, you may have 4 children. 3 of them you're very proud of. 1 of them has turned out bad, has no control of money, and you really don't want to give them any funds. You can leave them out. And then the last one is where the trustee has the absolute discretion of what they want to pay out. Again, when they say absolute discretion, we should still have a criteria for the trustee of some sort. And that, again, lawyers are expert on the best wording for that. Then we have the objective standards. The trustees shall determine necessary and appropriate for this support and maintenance of the income beneficiary or beneficiaries. They take a look at what is needed to support the lifestyle of the beneficiaries, and that's what they pay out. And again, they may be required to pay out part of it every year, or maybe all of the income every year, maybe be able to dip in the corpus, maybe able to take out a corpus. A lot of flexibility, but it should be stated in the trust. There's 2 types of beneficiaries. We're going to start with the remainder men. They get the assets when the trust terminates. They receive outright ownership. And a good example of that is the bypass trust that's used in marital trusting. And they really own the assets. The present interest has only use assets, and they have to use reasonable care and maintenance of the assets. So if I get the house for 5 years and it goes to my brother, that 5-year period I can't let the house go to pot. Figuratively and literally. I have to maintain it to the normal standards. I have to take care of painting it. I have to keep the yard in reasonable condition. I have to do termite control and other pest controls. In other words, what you do for yourself is a good standard for the present interest. But once the remainder person gets it, they can do anything they want with it. They can let the place rot. They can tear down the building, whatever. Then we have what's called the principal invasion discretionary beneficiaries. This allows the trustee to pay out in their manner that they choose, and it fires the corpus and not pay out the corpus. And this is, again, an example of 2503B trust, where typically the children of the grantor get some income or all the income. Sometimes they dip into the trust. Sometimes there's money left over. My experience with clients, however, is when we have a 2503B trust and it allows for the taking of the corpus and the income are usually gone before the future interest gets added. In fact, I actually had experience with a son-in-law was the remainder interest, and his mother had the present interest on 2503B. His mother used up all of the income each year, and she also used up the entire corpus. So when she died, he had nothing. So when you talk about principal invasion discretionary, you should be very careful, again, how you word it. Maybe they can take a certain percentage of the corpus, or whatever. Maybe it's all right for them to take it all. Failure to pay out the terms of the trust is a breach of the trust on the part of the trustee. So sometimes the trustee says, this is nuts giving it to this person. All they're doing is spending on drugs and alcohol. That isn't their decision. Again, it might be against public policy to encourage people to do that, but you can't go against the terms of the trust. If you don't like the terms of the trust, you should have a court change it. Per stirpes and per capita. Historically, per stirpes was a major issue and has been for a long time. And when I say a long time, the last 50 years certainly, where you inherit through your parents, and that is the way it happens. So if your parents are dead, you get their share. If the parents are alive, you don't get their share. But per capita is where everybody who's a beneficiary shares equally. So the children, grandchildren, and great-grandchildren can all get in equal amounts. That was very popular up again until about 50 years ago, and that is no longer the one you see. Almost every time you're going to see today is per stirpes, and in our society today, we consider that more equitable. You inherit from your parents. Power of appointment is very dangerous in a trust because it can have tremendous tax ramifications. We don't go into all of those ramifications in this course. It's to be covered in other courses that you're taking in taxation. But it might note that the power of appointment is typically found in a trust. And that power of appointment means that, again, the holder of the power can do what they want with it. There's two types. We have the general power of appointment, which again is very broad. It allows the trustee to benefit from it, their creditors benefit from it, or their estate to benefit from it. Now, you can protect yourself from the tax issues unless you have an ascertainable standard or 5x5 power. Those are two ways out of making it taxable for the individual. And any time a lawyer is involved or in the preparation of a trust, they'll make sure those are included. Another type is the special power of appointment. It's limited in scope and may not be exercised in favor of the holder, the power, the creditors, or the estate. So example, the first one would be my gift to my son, the power of appointment, so he can decide who within the family members need the assets the most that year, and that year gets the income. And at the end of 20 years, the corpus is reduced and distributed to everybody. Well, that would include my son. So in that case, what we would add is an ascertainable standard of health, education, and support, or the 5x5 power, where he can take up to $5,000 a year, or 5%, whatever is greater, out of the trust. The special power appointment would be, I give to my son John. I said, for all the family members except you, John, can benefit from this trust, and you are to decide which of the family members except yourself can benefit. That would be a special power appointment. Now, the power can be exercised during the term of the trust, during lifetime, or in termination, a testamentary trust. Again, a testamentary trust is when it comes out of a pour-over will, and which has the pour-over trust that gives the assets in control of the trustee at the end of probate. And special wording is best required for exercise of power to avoid mistaken intent. One of the things that's most missed on things like the bar exam, the CPA exam, and the financial exam, planner exam is when we have a power appointment, because they're not going to say, give you the power appointment. They'll say things like, my son John shall decide which family members will receive the benefits. That's a power appointment, even though you don't call out the term. We look at substance, not form. And if we don't exercise the powers, then it remains in the trust. And again, if you that can be a tax issue if you held a general power appointment without the ascertainable standard or a 5x5 power. We also have the power to invade the principal. And this is when income beneficiary can receive portions of the trust principal at the discretion of the trustee during the trust term. That is similar to what I talked about earlier with the 2503B. It should be very clear when the corpus can be invaded and for what reasons. Again, my experience, as I repeat, is that if you give that power to the trustee, the first generation, the ones with the present interest, usually wind up with all the assets. Let's face it, everybody can find ways to spend money. And I always hear the fact, well, the parents are going to be concerned about their children getting the income. Well, the parents who are the present interests sort of forget about their children when it comes to money, at least from my experience. If a principal invasion beneficiary is also a trustee, the trust instruments, sometimes state law, will often prohibit the trustee from exercising the power in their own favor. Again, it's best to say in the trust that if it's a general power of appointment situation, it cannot be exercised in favor of the trustee. Otherwise, again, we know who will benefit and who won't. Refund agreements, typically, and I'm going to run the situation that's real life, someone dies and there's a trust that has all the assets. It was a living trust and took effect at death. And at death, all the relatives and all the potential beneficiaries attack the trustee saying, give us our money. And they put a lot of pressure on the person. And if it's not a professional fiduciary or a bank or a trust company, the tendency is to get everybody off their back, to keep friendly with all of the beneficiaries. The trustee pays out all of the assets in the trust per the terms of the trust. Then 9 months later, the IRS and many times the state come after him for taxes. Also, we're going to find all the debts and debtors come after them. And that could be for years because there's statute of limitations tend to be very long on some of these items. So to protect the trustee when they're naive enough to pay out all the assets before paying all the bills and the taxes is the refund agreement, which requires the beneficiaries to pay back the money they receive to the trustee. And I might note that the beneficiaries of a trust are considered executors from the standpoint of the law if they are receiving the assets at death. So when I give it to my three children in fact become executors, so they're subject to the same liabilities as executor, and that happens to be a fiduciary responsibility for that money received. So again, if there's a situation, and it does occur, where someone uses bad judgment and gives all the assets out, he's created problems not only for him or herself, but also for all the beneficiaries that receive it. Types of trust, we have the living trust, which we've mentioned before, created by agreement between the grantor and trustee. The trustee derives authority from the agreement and state law. Don't forget the state law, because state law is very important in the area of trust. Testamentary trusts are established by testator, which will take effect only upon probate. And the trustee draws authority, in this case, from the probate court and receives the permit to use the trust for distributing the assets, generally called the letters of trusteeship. That's not true of all states, but most states, the letters of trusteeship is what makes it effective. And again, it's a great idea for for wills, when you have a situation where some of the beneficiaries probably aren't the best in the world on finances, or they need a guardianship, or maybe they're older and probably not in a state of normal conditions. They might have dementia, or other people who could benefit from the trust. In vivos trust, which means living trust in Latin, the revocable or irrevocable. Revocable trusts are used to control assets during lifetime. They're used for the will substitute. They're used for incapacities rather, in lieu of guardianship and conservatorship. Now, I might know that's only for the financial side. The management of the person is still handled by a guardianship or conservatorship or a special power of appointment, etc. But as far as the trust would not be handling the individual. Trustee is responsible for the taxes and creditors at the death of the grantor, as you can probably figure out. And again, if he pays it out, then we have the issue we just talked about in the prior chart. Irrevocable trust is used to gift, gets assets out of the estate. It protects against creditors and divorce. This is the one that you usually hear in the seminars about using trust. They don't say irrevocable because, again, people, they like the idea you get all the benefits of trust, plus you protect yourself from creditors. And it's really a choice. I can keep the benefits of the trust, or I can give away the assets and get protection. You can't do both. Special types of trust, we have the revocable ones that you're running into in your estate tax and income tax courses called the Meritable Trust, the ABC Trust. You have the Family Trust, the 2503B, which we talked about before, and also found in your tax courses. And you have the Pour-Over Trust for wills, and that's more likely to be in an estate planning class. Typically, irrevocable trust is the what we call Dynasty Trust or the Alaskan Trust, which is also known as the Generation Skipping Tax Trust, because it does avoid the issues associated with generation skipping. We have the Trust for Minors, which is the 2503C Trust, which up until we came around with the 529 plans was the major way for saving for child's education, and it's still used by people who want to control the assets. And so you give up some of the benefits of taxes in exchange for control. Then we have the Irrevocable Life Insurance Trust, the Gratz, Qualified Personal. In other words, the Remainder Interest Trust are all good examples of irrevocable trust. Grantor Trust is the most serious because it's done usually without intent and has big tax results. If the reversion of the trust property to grantor at any time, so the grantor can get the assets at any time, it can be a revocable trust, could also be a grantor trust. If the grantor gets the trust income or future possibility of grantor getting income, such as a reversion trust, that's also a grantor trust. The power of the grantor to control enjoyment of the trust. And finally, reservation of administrative matters that are important to the grantor. If you have any of those, and that's very broad in these, it's a grantor trust. And the grantor trust means that you are going to have taxes on the part of the grantor, not on the part of the trustee or the beneficiary. It was kind of interesting. The beneficiaries and trust get the benefit, the grantor pays the tax. And we'll hear about that more in subsequent modules. Summary: in this lesson you learned about the types of beneficiary payouts, per stirpes versus per capita ramifications, the impact of the grantor's trust status, and finally additional information regarding the role of the trustee, a very important person, obviously.